Hello, everyone. Today we are going to talk about how to protect your children after you pass. Welcome back, everyone, to the probate show, in which myself and Anthony Lung will talk about some of the probate cases and also give you some of the information. Especially in this episode, we are talking about the appropriate way and protect the children who you leave behind when you pass, specifically about the assets that you're remaining and how to actually protect the children's safety as well. So, with all that said, Alon, how are you?
Hello. Thank you for bringing me back on the show. And
You are,
hello, everyone.
you are so welcome. Thank you so much for sharing all the stories and experience and knowledge that you have about the probate as well. Um, let's start with the story you may want to share with the audience about a situation that you just have.
Sure. So typically, most people think that the only thing I do here is just write wills and trust all day long. But actually, on the other side of that fence is that we handle courtroom work that deals with the actual issue that's going on when somebody pass away and they don't have a will, they don't have a trust. And so, what happened at that point? And the story I'm about to tell you is basically, it's a young mother, single mom. She's raising this child. I would say I'll give a hypothetical age. She's about 10 years old. And,
Okay.
she passed away prematurely. So now she left behind this poor young little daughter to fend for herself. So the first question now is that, who is going to be the guardian, the person who's going to take care of this child, because there was no pre-arrangement that was made.
Mm.
And so at this point, it could be the grandma, it could be the grandpa, father, or it could be the dad, right? The biological dad. So luckily in this case, the dad is still around. So,
Okay.
he took up the responsibility. He take care of the daughter at this moment. But the other issue is that the mother actually left behind, life insurance, and she left behind a house and a bunch of other assets. And the based on the Arizona law is that these assets are supposed to go to the daughter. However, the daughter is only about 10 years old.
I
So
see.
how can
18. Yeah, she's not 18 yet, or is it the 18, like older than 18, where she can legally own everything?
correct? So she has to be 18 or older. Unfortunately, this daughter is not there yet, so she's considered a minor. And so the
Mm.
problem that we ran into, now this is a very, I would say, complicated case because we have to file what's called guardianship and conservatorship, as well as probate. So these two cases, we have to do it simultaneously somewhat.
Uh,
And this, what is tricky is that it's two different judge handling these two cases. And so basically,
uh-huh. Just so we understand correctly, why two judges, not one? Can you share a little bit?
generally we could have done it under one judge, but what happened is that the asset and where the mother passed away is a different county or different location together. So,
Ah,
so
okay.
there's a particular law where you can either file probate where somebody passed away, or you can file probate where the property is located.
Mm. So it's more complicated case because the asset is actually in a different location, I guess.
All right. So I'll
Yeah,
make it a little simpler for you.
sure.
Let's say if um, you know, your let's say if somebody passed away in Arizona
Mm-hmm.
and the daughter now goes and live in New Mexico
Mm.
or California. Well, wherever the daughter is, you need to start the guardianship and conservatorship over there because
Ah,
the court over there will oversee that child.
got it. The guardianship and conservatorship is to take care of the children, the child, the daughter herself, right?
Right.
Okay. In this case, is her biological father. You
Her
said.
biological father.
Hmm.
And
Okay.
so that's why we have to do two cases simultaneously. And the
Mhm.
tricky part is that every case is now becomes a court hearing, because the judge is very wary when there's a minor child involved, there's substantial asset, and every time we want to do something, we have to get permission from the court. This
Mm,
this creates like a lot of headache, a lot of obstacles in our way to help this dad who can help his child. And of course, like the dad has to come up with the money because he has no access to the money from the estate yet. So
mhm.
that means he has to come up with all these attorney fees to pay the attorneys in order to get these cases even started and paying the court fees and all that.
Okay. In this situation, just curious, the story that you share, is the father good to her daughter, close to to the daughter?
He is close to the daughter.
Oh,
You
that's
know,
good.
he has been in her life. The only thing is that he wasn't married to the mom, and
Mm,
so this is
mhm.
why the situation got complicated because they're not married.
Right, right. So yeah, so okay, so the situation is complicated because they are not legally married, and
Right,
then the child is still underage, and all
right.
the assets, like the thing getting even more complicated because of the location as well. The two different situations is take probably a long time to finish this, right?
Yeah. And
Yeah.
so, one of the issue I have right now is that I'm trying to petition the court to allow the father to take a certain amount of money every year from the estate and to provide for the child,
Hmm.
because it's like you as a single parent. Sometimes you make income, but it's not like you have a lot of income. You have enough to take care of somebody. Generally, when you have mom and dad together, there's two income, but now there's only one income,
Mm,
right? So it's only fair to say that the asset from the deceased mom should be used to help take care of the child.
got it.
However, the court is now telling me basically, the father should be burdened with all the expenses, and he shouldn't take out any money from the mom estate. And so,
Oh,
and so
right.
now it becomes a battle between me and the judge, basically.
Okay. So in regarding to how where the money is from to take care of the children, the daughter.
Right. And we're
Okay.
not been asking for a lot. We're only asking for, just what's reasonable enough to help take care of this child.
The reason why the judge do that is just to make sure that the child have the full access to the estate when she's become 18, I guess. Is that
Exactly.
now? Okay. Got it. Got it. But the father maybe not be in the financial situation to be able to provide support to the daughter.
Yeah. I mean, Lam, can you imagine, like, if this happened to your family and all of a
Hmm.
sudden, the court is telling you that you're not allowed to use any money, you have to use your own money, to
Yeah.
take care of your children. It's tough, right?
This is difficult, especially if the father hasn't been with the daughter for a long time as well, so if he doesn't have that experience to take care of the daughter um, in this situation because they are not married anymore, right? Um,
I mean,
Also,
that's a lot of couple out there right now that are not legally married, and
mhm,
they have a child together, but they pretend to be married, I guess is the word for it.
mhm.
But without that legal document saying you're married, you're not married in Arizona.
Yep, yep, yep. Um, so and then I don't know if that is a situation or not, but for the properties, the real properties, the houses that her mom left behind, is there any mortgage payment remaining that her mom still have to make?
See, that's another problem we face too, is that there is the continual mortgage payment. And
Yeah,
dad is struggling to pay both his mortgage and the mortgage for the estate, because
right.
right now the court has restricted all money to be used. So we have to find a way to release some of that money for dad to be able to pay for these mortgages.
Exactly. Otherwise, the bank can foreclose on the house, right? If that doesn't keep making the payment, and with the intent to give that access to the daughter, he probably doesn't want a bank to have that.
Exactly. So
Mm,
the point being is whenever you get the court involved, it becomes a whole new ball game. There's so many obstacles, so many restriction. You do not want to create this kind of headache for your family. And by
right,
having an estate plan in place, you avoid all that. You avoid the attorney fee. You avoid the court involvement. It makes things a lot simpler for your family, to not have to deal with this during this difficult grieving time.
right. Yeah, because no one know for sure when they pass, right? When they die, it could be happen now, it could happen tomorrow, and the further we delay on planning for that when it happens, um, the worst the family could be in, the worst the family situation could be in. So, uh, so, what is the appropriate? Had her mom still alive, what should be the right approach for her mom?
So if we were able to go back in time and say mom was alive, I would tell
Mhm.
her she needs to put together her wills and trusts. So, and in that will, she has to nominate a guardian. So it could be the dad, it could be someone else. And then in the trust is where she placed all the asset. So that way, there's no restriction except for what's listed on the trust.
Yeah,
So
yeah,
like you can the trust generally provide for a flexible language that whoever is the guardian can take enough money to provide for the child basic needs
right,
as long
right.
as they do proper accounting, they keep record, um, and so that satisfies a lot of the requirement and enough protection for the child.
Yeah, yeah. So the living trust is not only just the way to distribute, I guess, the properties of the deceased person, but also providing guidance on who gonna be the person taking care of the children as well,
Correct.
right? Especially it's important when the children is under 18, right? Because they cannot legally do anything if they are under 18. They cannot legally own anything under 18, right?
Correct.
So have the guardian, right? Is that the word?
So it's
Uh,
it's a guardian and conservator. However, if you are the biological parents, you do not need a guardianship, you just need a conservatorship.
right, right. So what's the difference between them, like
So
conservatorship?
so a guardian is basically like who has custody of the child,
Okay,
with the physical custody of the child to take care of that child. The conservatorship is who has the ability to manage money on behalf of the child,
money to the child. You said.
to manage the money for the child. So like
Got it.
so kind of like if Congress has the ability to write the check,
Ah,
the
I see.
conservator has the ability to write the check.
So even if the father is the guardian of the child, he may or may not have the right to write the check for her.
Correct. So it could be a whole different person.
Ah,
So it's
okay.
like mommy come to daddy to have daddy write the checks out to take care of the child basically.
It's especially important in the situation that the couple are not happy together, right? I mean, the father, I'm not sure about your case, but the father who's still alive maybe still love the daughter, right? And he can have physical take care of her personally, but the mom doesn't want to give any assets to the father because they're not happy together, and don't want to control the money. Maybe give the control of the money to someone else that she trusts more.
Right.
Right?
And that's usually what people do.
Mm-hmm.
They would nominate the biological father or mother to be the guardian, and they
Mm-hmm.
would nominate like their grandpa or grandpa or
Right,
grandma to be the
right,
guardian, to be the conservator.
right. But everything is clearly defined in the living trust that happens, right? And it doesn't involve the court anymore because it's already there. It just needs to be executed, right?
Correct. So that's where the estate planning come in. Is that when a client come to me, I plan for all those scenarios, and it's
Mm-hmm.
all gonna all be clearly laid out in the document. There's no misunderstanding as who has what roles of responsibility. It's kind of
Mm-hmm.
like if I was to be in the judge position and I'm planning these things ahead of time
Got it.
with you while you are there with me.
So let's say in the situation that they have the living trust clearly defined of what's going on with the child after I pass, for example. Obviously, I don't. The child doesn't have to go through court and go through any probate court anymore. Um, then what kind of action is there any action that she have to do to like execute the living trust, or see what I mean?
So as the trustee, you're talking about the trustee, right? Not the kid.
Right, right. When they have the living trust in place, right, everything set up, like the child gonna be stay with her father, the money gonna be controlled by her grandmom and things like that. Everything is set in the living trust. So obviously they don't have to go to the courts to
Correct.
set up everything anymore. When I pass, does my child have to do anything to make the living trust executed? I guess I don't know the right word, but to tell the world that this will be the thing happening.
No, it will be the trustee who would do most of the work. The
Okay,
trustee will probably reach out to an attorney to have the attorney review the trust and advise on what to do. The trustee has to do the report every year to the beneficiary and to the guardian.
I see. Okay,
And then, of
so then
course, the trustee has to follow the direction of the trust. If the trust say all they're going to give out is $20,000 a year, then that's all they're going to be able to give out per year.
got it, got it. So the action, like when we have the living trust set up, it does not have to go through the court, but the trustee have to reach out to an attorney to tell the attorney about the situation and make everything happen for for the child.
So the trustee doesn't have to reach out to an attorney,
Okay.
but it's advisable that they should do it because
Hmm.
lay people have a difficult time understand fully what the trust uh,
Ah.
meant because there are sometimes the direction it might seem simple, but it could mean totally something else.
Okay, okay, got it. That I think the main question I want to ask because I want to make sure, like, okay, if I pass away, the trustee have all the legal documents, right? I guess when the trustee try to get the money from the bank, the only thing that the trustee have to do is to give the living trust document to the bank to show that they are the legal person who can withdraw the money according to the trust.
Generally, yes.
Okay, got
So
it.
we
But
also have this thing called succession planning. So what
mm,
happened is if somebody passed away and they left behind a trust, the client can come to us and we help them prepare all the succession documents. With
ah,
these document, it has the seal of approval from the attorney office. And so it makes the job of the trustee easier when they deal with the bank. The bank won't question them.
yeah, yeah, yeah. I think that's a good idea to reach out to the attorney office as well, just mainly because there's some detail that the trustee may not be aware of and maybe not even fully understand about the terms and the condition of the documents. Because probably most of the case, the trustee is not a part of the estate planning discussion, right?
Generally, they're not. So they don't know what is in the trust. They don't know what to do with the trust. They don't
Right.
fully understand their responsibility until they speak to an attorney.
Yeah. Yeah. Okay. I think that's a great discussion today, and thank you everyone for watching. Like usual, if you do have any question about this specific show or any other question about probate, um, feel free to contact Attorney Lung as well. I'm sure that he'll be more than happy to answer any question that that you guys have. The next show that we are all having is also on August 4th at noon as well. Hopefully to see you again in that show. Thank you
Thank
so much, everyone, for watching.
thank you, everyone.